Not just here, just me.
I think we're ready, Joe.
Okay, Patrick, you ready? Okay, court call CV 54-888, the final hearing, Valdez versus Andrews Investments Company, LLC. This is on a remand from the Court of Appeals. Announcements.
Mike coming out for Valdez. We're present, we're ready.
Okay, and again, this is the final hearing,
Yes.
and we. What's your approximate time, just so I know?
I think we can put our case on in 30 minutes. I think.
Okay, we'll try for 30 minutes each. You'll keep your time for me. And then, do you want to have openings? Okay, opening.
Your Honor, it's, this is a tangle that we have, right now, Court of Appeals has ruled in our favor. Right now, all we're doing is trying to figure out how do we get our property back. There's contention as what the expenses were at the time, when, Mr. Robnett, started to secure the property. And, what we contend is that most of those expenses are not available to them pursuant to the statute, that they come to another item and things that doesn't necessarily secure the property. It's originally sold or rented, but it doesn't secure the property. Under statute, it says just to secure the property, from vandalism and that nature. So we contend that those expenses aren't there. And then we also incurred enormous amount of attorney's fees. We have 2 attorneys on the case that took this case on, and so we're looking at a lot of fees. So we'd like to put that well to move forward.
Okay, Mr. Cunningham.
Judge, I don't think they're entitled to cover attorney's fees, but I will address the other issues. We're here really claiming costs under section 3421 of the tax code, and that has in 3421 it has a formula basically as far as the amounts to be paid, and it discusses also, Judge, section, well, it's 3421. Correct me. 3421 G subparagraph 2, which talks about costs and what costs are allowed. And I agree with Patrick that there's a dispute over what costs should be recovered under this case. And so we brought exhibits to talk about that. Judge, the statute 3421A allows and requires the owner, who of course is now St. Andrews, requires to pay the purchaser, the Valdez, the amount the purchaser bid for the property. We'll show you that. The amount of the deed recording fee, which is $30, and that's in some of the records. The amount paid by the purchaser as taxes, penalties, and interest. And then the 4th element is cost on the property. And then the 5th element is the redemption premium of 25% of the aggregate total. I think the only way we read that is the aggregate would be 25% of the amount of the other elements of there. purchase price, recording fee, amount paid, as ad valorem taxes, cost of the property. So that's where you get to that number. And then on G2, it says cost included. And the language is the amount reasonably spent by the purchaser for, quote, maintaining, preserving, and safekeeping the property. And I think those are the key phrases that will be faced with here today.
Okay.
And it talks about some other items there, some specific things that can be recovered, most of which don't apply to this case. Property insurance, repairs required by the local building code, discharging a lien imposed by the city of Midland. There'll be some evidence on a water bill that had to be paid, whether that's a lien or not, I'm not sure. Homeowners Association doesn't apply. And then impact or standby fees imposed under the local government code or water code. I have no idea what that is, but it doesn't apply to this case, whatever it is.
Okay.
So with that, we're ready to proceed.
Okay, call your first witness.
I think it's really our part.
Yeah.
Yeah.
It's our part.
Yeah.
So I would call Victor.
I looked at him, but I said it to you, so,
Thank you.
okay, call your first witness. Sir, before you sit down, raise your right hand. You will solemnly swear or affirm the testimony you're about to give in this matter, and give the truth, the whole truth, nothing but the truth, so help you God. Yes, sir. Have a seat and pull close to the microphone. State your name, spell your name for the report.
My phone on this.
Spell.
VICTORBALVEZ.
Okay. And for the lawyers, you can move about freely, you can approach, you can go over and look at over his shoulder, he can look over your shoulder. So go ahead.
Mr. Valdez, where do you live?
Midland, Texas.
All right. And were you, was Manuel Valdez your father?
Yes, sir.
Did you and Manuel have a business during his lifetime where, in part of it was to buy distressed properties and fix them up and either sell them or rent them?
Yes, sir.
And you were you actively involved with your dad in that business?
Yes, sir.
And do you have personal knowledge, because of your participation or observation, of the sale and repair of the property involved in this case, which is, let me get it right, it's the Sturgeon property that has a legal description of west 39 feet of lot 6, and east 26 feet of lot 7, lot 1, Barbadale addition to the city of Midland. Were you actively involved in his acquisition and subsequent work on that property?
Yes, sir.
And did you have occasion to view the property both before and after the sale?
Yes, sir.
And you and Manuel, and approximately when did your dad die?
A year and a half ago.
And so your mother is the executor of the Valdez estate, is that correct?
That's correct.
And this is your mother, of course, here in the courtroom.
Yes, sir.
You understand that at this point in time, the claims that we're going to talk about here in a minute are really owned by the estate of Manuel, because he was the one on this sheriff's deed. That's who they actually deeded the property to, Manuel.
Yes, sir.
All right, let me work through these exhibits with you. I'm gonna give you a set of them so that I can sit at the table as we go over them.
Now, is there a stipulation as to the admissibility of the exhibits, or we're just gonna go item by item?
I think we should go line by line.
Okay, that's fine.
Your Honor, not to be difficult, that's part of the question.
Right, I understand. I just want to make sure.
I think some of them are fine, but they're public records, but some of them, Judge, do involve our calculations and
Right.
things they wouldn't have knowledge of. Okay, Mr. Valdez, would you go to exhibit number 1?
Yes, sir.
And you recognize that document as the sheriff's deed. That was, indicates the date of sale of September 5th, 2017. And where the sheriff deeded the property to Manuel Teixeira Valdez. You see that?
Yes, sir.
And that is, of course, your father.
Yes, sir.
All right, and this appears to be a true and correct copy with recording information of that document. Is that correct?
Yes, sir.
I move to introduce 1.
No objection on.
Number 1 for the, we'll call you the petitioner. Number 1 for the petitioner is admitted.
All right, now go to number 2, please.
Yes, sir.
Now, number 2, of course, has a cover sheet that obviously was, may I approach you?
Yes, both sides may freely approach. And is this the court's copy or is this the official copy?
I think that's just court's copy.
Okay.
I think, Judge, I'm trying to get you where you can follow what we're doing.
Okay.
Sorry, I didn't give you an extra set.
No, you're good.
Yeah, okay.
I just want to make sure that the original gets to the court.
Now, Exhibit 2 has a cover sheet, and it has some backup information. And do you recognize what exhibit number 2 is?
Yes.
Is that the listing of the ad valorem taxes that your father ended up paying for this property from actually 2011 to 2020?
That's correct.
And attached to the cover sheet are the actual receipts indicating that the taxes were paid by your father.
Yes, sir.
And your father owns some other property, and so when we look at these documents, the specific property involved in this case is just a part of his other tax bill. So he had several properties he was paying taxes on, right?
Yes, sir.
But on each one of these tax books, have we indicated that this property that we're dealing with in this case was indeed one of the properties that he paid taxes on? And the property number for this particular piece of property with the Midland Central Appraisal District ends in the numbers 3794. Let me be sure. I may have that wrong. Hold on. Yes, it ends in the numbers 10044. That's the property number associated with this actual piece of property, correct?
Yes, sir.
So that attached to the cover sheet, we have tax receipts from the tax district. And I want to go over those with you just briefly. Item number 1, it says taxes 2011 and 2015. Now, is that amount the amount you were required to pay at the time you purchased the property, your dad purchased it?
Yes, sir.
And then the rest of these were 17, 18, 19, and 20. Those are simply taken off of his record showing Manuel Valdez paid those taxes. I'm going to go over another kind of twist of this with you in a minute. But at this time, Judge, I'd like to introduce Exhibit 2.
Response?
Only for edification purposes, because I don't believe these are actual taxes that Mr. Valdez paid. It's proof in the affidavit itself that it's a different owner being credited with paying the taxes, and Mr. Valdez that one, Guadalupe Vega. So on the tax roll, it doesn't show that I'll let it in for purposes of that, but not because the truth or veracity of it, that it's, they did not pay. Somebody else is credited for paying.
Response?
That's not what they say. Up at the top, it says paid by Manuel Valdez.
So, he didn't have an objection, so his concern goes to the weight, but admitted.
So Exhibit 2 is in your.
Yes.
Now, Victor, I want you to explain the situation of why another name appears on some of these tax records on Exhibit 2.
What happened?
Let me ask you the question. The receipts show on Exhibit 2, if you need to refer to it, the receipts show that the taxes were paid by Manuel. But there, for some years, is another name shown as the quote owner at the tax office. And that's somebody named Vega. You aware of that?
Yes, sir.
Okay.
My dad sold the property to the man, and, but we paid the tax for, when my dad realized that he could sell the property, he paid the taxes, and the receipts were made out to my dad, on the taxes.
Let me work the, after you purchased this property and while the case was being appealed, had you, after y'all did some initial work, did you have an agreement with this Mr. Vega to buy this property?
Yes, sir.
And was that agreement reduced to writing? Was there a written document
Verbal.
between you and Vega, or your dad and Vega?
Yes, sir.
I mean, listen to what I'm asking. Was there a written contract signed between Manuel and Mr. Vega regarding the sale? A written contract,
Yes, sir.
okay? And do we have a copy of that? I've never seen that in all these years.
It was verbal.
I'm sorry?
I said it was verbal.
It was verbal.
Well, that's what I'm asking.
Right.
Okay. That's why I was somewhat surprised by your answer. It was a handshake. It was a verbal deal, correct?
Yes, sir.
So there would not be a written contract. Is that correct?
That's good.
All right. So Vega moved in to the house, is that correct?
That's correct.
The intention was you're going to sell it to him.
That's correct.
Were you advised after this case proceeded on appeal that you could not sell the property to Mr. Vega because we didn't know if you owned the property yet?
No, I was not.
All right. So how long, well, did someone, either yourself or Mr. Vega, tell the tax office that he was the owner of the property? Well, it shows, that explains on Exhibit 2 why the tax office is showing somebody named Vega as owner of the property, right? So what happened is you had this verbal contract to sell. You found out you couldn't sell. So what happened to Mr. Vega?
Yeah,
Mr. Vega had spent some money on repairing painting and doing some other things out there at the house, right?
That's correct.
And we're gonna get to that, we're not there yet. But when the deal fell through, did your father reimburse Vega for some of those costs that went into his house?
Yes, sir.
And we'll get to that, those are the painting invoices, aren't they?
Yes, sir.
All right. So from exhibit 2, the tax office was showing Vega as the owner, but each year your dad has shown on the receipts actually paid those taxes
That's correct.
for each and every year.
That's correct.
And so the total for those taxes as shown on exhibit 2 was $8,152.09, correct?
That's correct.
Now, I want to show you what's been marked as exhibit 3, or if you would go to exhibit 3.
I'm in the suit.
Thank you. You recognize that as a copy of correspondence found between Karen Hood, the tax assessor, and to your dad, Manuel Valdez.
Yes, sir.
And this letter informed Manuel on July 31st, 2018, that the property had been either redeemed or an affidavit for redemption had been filed with the tax office, correct?
Yes, sir.
And that was filed, of course, by Ms. Jackson on behalf of St. Andrews.
Yes, sir.
And it indicates that she deposited at that time $35,912.50. Is that correct?
Yes, sir.
Very good. I move to introduce 3, Your Honor.
Response?
No objection, no.
Objection or no objection?
No objection.
Commissioners 3 is exhibit.
Now, I want
Is
you,
it been?
thank you, Judge. I want you to go to exhibit 4. Exhibit 4 says Valdez expenses. And I want to work through those with you. The first page of exhibit 4, of course, is just a summary of the expenses that you're requesting to be reimbursed under the tax code, correct? That's what you're asking to be reimbursed.
Yes, sir.
All right, so let's go through them. What was the condition of the evaporative air cooler on the property when it was transferred to Manuel? And so the first part of exhibit 4 is a $466.59 repair bill, so you can get air conditioning in place to Sierra Air Conditioning, correct?
Yes, sir.
And did you feel like that was certainly a part of the maintenance, repair and safekeeping for this property?
Yes, sir.
The next cost is something dated February 5th, 2018. And that is to the Midland Handyman. I'm gonna let me, I'll look over him so you can be looking at what I'm
Yes.
going through with him. Thank you.
I got 2.
This is 4.
Yes. Yeah, that's cool. So you've got an extra copy, well, that makes it even better. So exhibit 4, the first item is the Sierra Air Conditioning. Now, the second one is to this Midland Handyman. Does this document indicate who the Midland Handyman was?
Yes, sir.
And what was his name?
I'll say you know.
And did your dad know Mr. Yulfo? Did he know him?
Yes, sir.
So was Mr. Yulfo hired then to do some work there at the property?
Yes, sir.
And was Mr. Yulfo paid $7,500 associated with the February 5th invoice?
That's correct.
Now, on that invoice, does that itemize, tell the court, told Mr. Valdez exactly what work that Mr. Yulfo performed there at the property?
Yes, sir.
So the first one was remove old floor, debris, fence, trash in and out of the house. What condition was the flooring in when you went in there after the purchase?
It was bad.
All right, and when you say pretty bad, tell the judge why it had to be repaired in your opinion.
It had holes in there.
I'm sorry,
It had holes in it.
what was the flooring in the house safe for people to walk in there?
No,
And when you say holes, just try to go, I know you saw it, so try to go into some detail with, about what rooms, what type of holes there were, so that the judge understands why you spent the money to replace the floor.
uneven floors.
Sorry?
Uneven floors.
Oh, uneven.
That was holes in there. No,
Were the floors sagging in part?
yes,
And were there actual holes in portions of the floor?
Yes. Been known for a long time.
Sustained, don't we?
So the next item is plumbing repair. What was that about? What was that about? What had to be repaired about?
leaks in
And Mr. Yulfo specifically says in the laundry. What, could you tell us more about that?
it. You open the water, you say,
So there were actual visible water leaks.
Yes, sir.
You tried to pressure it up and run water through it.
yes, sir.
He goes further and he says, checks the breaker box, electrical cables. What shape were the appliances in the house?
Everything is good.
Mr. Sturgeon, we found out, hadn't lived there in at least a couple of years. Is that correct?
That's correct.
He was in the nursing home.
That's correct.
He had to pay taxes for the previous, I guess, 8 years, from 2011 to 17. The previous 6 years, there've been no taxes. Right.
Yes, sir.
That's what we found out. That's why we were in this case. It was a tax foreclosure sale where your dad bought this property, right?
Yes, sir.
What condition were the windows in it?
Most of them broken.
And how about the roof? What condition was the roof in?
Leaking.
So, did you replace some of the windows?
Yes, sir.
And do you feel like that was safekeeping and preserving this property? Because
Yes, sir.
people could climb in, there was no security, correct?
That's correct.
You replaced the front doors because the doors were broken, is that correct?
That's correct.
All right, now, let me go back to this. Mr. Yulfo says remove appliances, remove cabinet in the house, clean up the yard, remove all the trash and debris. Did you feel like that was maintenance and preserving and safekeeping the property to pay Mr. Yulfo to do these items that he listed?
Yes, sir.
Now, the next, did you also pay, it's not on this list, a $30 recording fee, and that's shown in one of the documents I believe we're going to introduce. But your dad was out an additional $30 for recording the sheriff's deed, correct?
That's correct.
And that's allowed by the statute to recoup that $30.
Okay. Yes.
Okay. All right, the next part is the city of Midland. Filed a land, actually did file a land, it says. You got a letter and a notice of it, that, June 18, 2018, is that correct?
That's good.
For $1,105.87. And your dad pay that to get that land removed by the city of Midland.
Yes, sir.
And that's item number 3 on exhibit 4, isn't it?
That's good.
All right. Now, the roofing. That's the next invoice. Now, you paid, your father paid, it says, paid in full, somebody signed it. Is the person that signed it here, is that the person that was working at Best Roofing?
That's good.
Did you know him? The guy that did the work?
My bad.
Okay. And so, he actually removed and disposed of the existing shingles, and he put a new roof on, didn't he?
That's great.
He charged $10,200.
That's great.
Now, in order to try to bring this into the idea of safekeeping and preservation, you will see that we, as part of our claim on exhibit 4, we cut that bill in half already, that roofing bill. We did that, didn't we?
Yes, sir.
Now, do you believe, based upon what you saw and your viewing of the roof, that it could have been reasonably repaired to stop all the leaks in it without replacing the entire roof?
Well,
And is that why your father had the roof repaired? Because it couldn't be repaired. I should say replaced, because it couldn't be repaired.
that's great.
Objection, Your Honor, I'm not sure you can speculate that what is that.
Okay.
Don't, sustain, don't speculate, just rephrase.
You
I
have,
have a question. So what was cut in half?
the item number 4, which says best roofing, that's on exhibit 4. On Valdez expenses.
Right.
So you cut that in half because we knew there'd be an argument that when you put a new roof on, and that's not preserving, and that's not safekeeping or maintaining. So you cut that in half in order to ask the judge for what you feel is a reasonable amount.
That's great.
So the 10,002 is
What's the total?
5,100.
Yes, so we got 5,100 on there.
Okay. All right.
Now, the last item is this issue of the painting. We have receipts for $3,700 to somebody named Juan G, right?
That's good.
Now, I'm going to go back now and remind us that these receipts, Juan, were actually given to something referenced as MGPC. What is MGPC, or your understanding of who that was?
Well, the person my dad had sold the house to,
Mr. Vega.
Mr. Vega,
Okay.
he did some repairs on the house. But they had to reimburse him back. When we found out we couldn't sell the property, they had to reimburse him when we do that. To get out of that house.
And with your dad, the reason you have these receipts is because your dad asked to see them so he could reimburse Mr. Vega. He wanted to know the exact amount, didn't he?
Yes, sir.
So Mr. Vega provided this to your father, and your father paid him $3,700 because he couldn't sell him the house, and your dad thought that was what should have been done.
That's right.
So that's your total cost that you're requesting today is reflected on exhibit 4 is $17,872.46.
That's great.
I moved to introduce 4.
Response?
Not as the way that this show,
I'm sorry.
not as the way that.
So, admitted any concern regarding the weight of the evidence.
We understand they don't agree.
Right.
Yeah.
It's admitted.
Now, let me skip ahead to exhibit 6, because that's simple. Exhibit 6 and exhibit 7. Would you go to those, please, in front of you? Six and 7. No, 6 and 7. Recognize those documents as actually coming right out of the tax office files, a redemption certificate filed by St. Andrews. And exhibit 6 is the redemption receipt that we received from Ms. Hood that was sent, of course, to St. Andrews. You recognize that?
Yes, sir.
And then number 7 is at least page 1. I don't know why we don't have page 2. I'll withdraw that, Judge. We don't have the full document.
7.
I moved, yes, 7. It's not all that important anyway. Exhibit 6, I moved to introduce.
Response?
No objection.
Exhibit Fisher 6 is admitted. Do we skip 5?
We're going back to
Oh, okay, just making sure.
do you have 5 in front of you, Victor? All right. Now, based upon the evidence and the claim, exhibit 5 is what we're asking the court for, and our suggestion to the court about how he should interpret, or at least our request under tax code section 3421. And so we put that in one sheet so the judge would know, and of course, Ms. Jackson would know exactly what it is that we're claiming here today and how we calculated our damages, correct?
That's correct.
And so I want to work through this so that we all understand what you're asking for. Item number 1 on exhibit 5, the $28,700, is that the amount that your father paid at the foreclosure sale?
Yes, sir.
And then the rest of this just comes off these other exhibits. We had the Lord taxes, $8,152. That would be, of course, the exhibit we introduced on that. And then the Valdez expenses, exhibit 4, which is the $17,872. Correct?
That's correct.
That's where we're getting those numbers from. Now, the aggregate amount of those 3 items, where the statute talks about a redemption premium of 25% of the aggregate total. If the property is redeemed within the first year of redemption. By the way, we had an argument, of course, about the timeliness of the redemption affidavit. We fought and we lost that battle. But we ought to know that it was done within 1 year of the sale. She filed her redemption within 1 year of the sale. Correct?
Correct.
All right. So we're asking for a 25% redemption fee or premium on the aggregate total. The aggregate total is on exhibit 5, the $54,724.55. Correct?
That's correct.
And it's the aggregate total of the payment at the sale, ad valorem taxes, and what you're claiming is your costs and expenses for preserving and maintaining the property.
That's correct.
If you add those numbers, it's $54,000.
That's correct.
25% of that number is $13,681.14. That's the premium.
Yes,
So you add that premium to the aggregate amount. And that, the gross claim then was $68,405.69.
correct.
And then on this exhibit, of course, you've given St. Andrews credit for the amount that they ended up actually paying. I believe they made 2 payments, but the total ended up being, I think, $35,912.50. Is that your recollection?
Yes,
Okay. And so you give them credit, and your claim today is $32,493.19. You're asking for an award of that, plus the amount, of course, deposited, under section 3421, correct?
correct.
Password.
Did you, offer fine?
Oh, well, for purposes of a summary exhibit of the evidence, I would offer exhibit 5.
Response? All right, 5 is admitted. Okay. Mr. Cordero,
Thank you. It's relevant. When did you start working on it today?
Or 10 years, probably.
10 years? And you have personal knowledge of everything that you testified.
Yes.
You got up on that roof and you checked it out.
Yeah, I didn't personally.
Heads up, you didn't check it
I didn't
out.
hear what you said.
I didn't personally.
So, let's go over a few things and then we'll start with something that sticks out like a sore thumb. According to the tax office, fellow owned property.
According to the tax office,
I don't object to calls for legal conclusion. And what the tax office says the ownership is has nothing to do with the real ownership. That's an administrative something for the tax office. We're not bound. You're not bound. Nobody's bound by what the tax office could show me owning the property. That doesn't mean I own it.
That is not true. You have to have a document that goes to the tax office that they get from the recorded documents in the Midland County Clerk's office.
Okay.
Let me finish.
If they have that witness,
Well,
You have to get a recorded document, whether it's a contract, a deed, or a warranty. You have to have a document recorded in Midland County Clerk's office before the tax office will change title at all. The idea that I could go up there and I can say, I own Mr. Cunningham's house, wouldn't fly. Like, you couldn't say that for anything. You couldn't do that for anything. You have to have a chain of title, and they keep a chain of title. As it stands now, there is not a deed back from Ms. Vega, Magalan Vega, back to the Valdez. There is not. I've got the last recorded deed in the chain of title, and it's in 2018-17-061. There is not a change. There's not a deed back.
that's not before the court, though. There's no evidence.
No, I'm just saying that there is a document, and I can, Midland Central Appraisal District, which he has already put on record, keeps record of that.
And what I'll do, you response real quick.
well, my response is that's not testimony. That's evidence that the tax office needs to come tell you. That's their defense, and it's irrelevant. It doesn't matter who quote owns it. We know who owns it. It's St. Andrews, according to the Texas Supreme Court. So that would make the whole argument. Nobody could recover under the statute.
Here's what we'll do. I'm gonna overrule the objection, allow you to answer it, but understand the explanation. So, go ahead.
So, Mr. Vega, you have, you misspoke earlier when you said that it was an oral agreement between you and Mr. Vega. Is that correct?
it was nothing going to do.
So you don't have any proof what was done?
It was an agreement to
So you don't know if it was a written agreement or oral agreement?
as far as I know, it was a oral agreement.
Okay, but you don't really know.
The honor, it's been asked and answered. If they got a document that's recorded or it's in the tax office, let's see it.
Overall, he can answer that. That goes,
I think he already has.
well, that goes to his credibility, his lack of knowledge or. Go ahead.
All right. So, okay, so somehow during this process, your dad transferred the property to a third party.
Object to the form. But whatever the tax office is showing doesn't mean the property was ever transferred. If they have a document showing a transfer, bring it, and we can talk about
It's crossed though. It's open cross,
it. Okay.
so overruled, but your point is taken. It's open cross.
We're gonna go down to the tax office to get that certified, bring it up here. So they can see that there is nothing.
If it's,
Mr.
it'll be considered when it's before the court.
All right, so at some point, is the property vacant now or somebody still living in it?
Somebody's doing it.
Okay, so somebody's there now.
Yes.
Knowing this whole time that y'all might not get title to the property.
Well, we have come to court here. We've been fighting this for a long time. I think we were saying just as what we did, but we purchased the property at a tax sale. We didn't have no, we thought the property belonged to us.
I don't know. Okay, non-responsive, Your Honor.
Sustain. This answers your question, okay? Mr. Cunningham will be able to ask you some questions also.
Okay, so, how much did you sell it for?
I didn't come prepared for that because that was my dad. I didn't say. You asked me to provide something. No, I work with my dad. I went to purchase property with him, and I would help remodel the property sometimes. And that was about it. But his business wise, how much you sell it for, how much you charge for, that's something that they pretend.
How about this question? Your dad was known for owner financing his property. Did he owner finance his property?
Like I told you, I came to auction, I went to foreclosure with him. I went, looked at the properties, I would help them remodel the houses. And I would go.
One more question. You have to know this, were there payments coming into the house for this house? Were you receiving a check for 106, water, piece of water?
That, I don't know. I know he sold the property to Vega. I was still learning whoever the name was, and he had to reimburse him back because he couldn't sell the property. That's as far as I know. He found out he couldn't sell the property, so we bought it at a tax sale. We did everything we needed to do correctly. He sold the property. When he found out that he couldn't sell the property, he had to give the man reimbursement everything back because he couldn't sell the property.
Okay, so do we have any evidence of that payment to Mr. Vega?
He's already testified to 1 minute agreement. It's an oral agreement, so no, he wouldn't have any evidence of it.
That wasn't my
Am I not
question.
hearing it right?
I think the objection overruled. Go ahead and ask your question.
Do you have evidence of your father paying back Mr. Vega the money that he held?
Evidence of the oral agreement.
No, just that, yeah, well, evidence of something.
Okay.
But
I don't know what that is. I don't know.
Did you write a check to pay him back, like one big check?
I don't remember. I mean, if you give me time, I can find out all that stuff out.
Okay. So right now, as it stands, could you provide, are you the executive of the state?
No,
Your mom?
yes.
Okay. So can your mom provide a deed back to St. Andrews, like today?
You were deed for property?
Yeah. So I mean, that's what's supposed to happen.
Why, basically, that's what the court rules, yes.
Well, the court already ruled.
Okay, there's nothing for me to find. I mean,
But can she, does she have title in her
No,
name?
no, I want to check. it's a legal conclusion. And you gotta make a ruling first. I mean, we don't sign up a property until we have some understanding of what they're gonna pay for the property. And that's what we
That's a good point.
Well, the point is that we get the property, now we're just doing the damage. That's,
I think it's all a unitary action. I mean, the Court of Appeals has ruled, and has remanded for consideration. That's really not an issue the court decides. It's just kind of a mechanical decision when it happens.
all right. So let's go over these expenses that are part of the, house. And come abundantly clear to me that you don't necessarily work that closely all the time. So was this one of those properties that you worked with them closely?
Let me tell you, my dad purchased one property, purchased, he owned over 100 properties here. So it wasn't just, I'm all focused on just on one property. Sometimes we have more than one property, one at one time. You know, but I did go to the property, and our property was very, very, very bad condition.
Okay. As of the date for the sheriff's office.
That's right.
Okay. So, let's go to the bill. So, your attorney has made it clear that in order for you to get cost reimbursed for the house, you have to have had, to secure the home, you know, make sure the well-being of the property. Yeah, you do understand, right?
Yes, sir.
Okay. I want to make sure you get the language right. Under the cost, oh, here it is. The cost. It's the amount reasonably spent by the purchaser for the maintenance, return, and safekeeping of the property. Okay, so let's look at the AC. How does that preserve and repair, or you know, how does replacing the air conditioner or replacing the air conditioner have anything to do with that?
I guess if you don't have the condition, you can leave the windows up, the doors open, what do you do?
Well, we're not talking about somebody living in the house. We're just talking about securing.
Up to the judge.
Well, it's more than secure, the statute has other words too. So.
Well, it does say, it says, maintaining, preserving, safekeeping of the property. Okay, so how does it maintain, preserve, or safekeep the property?
You be the judge.
Okay, so let's go through, so that's the air conditioning. Let's go over the money spent by Mr. Woolford. Okay. We had a long discussion about how bad the floors were, right? That's a concrete slab property. It's not pier and beam, correct?
Correct.
So what holes are you talking about? Like through the concrete?
Yeah, there's some.
Holes through the concrete?
Yes.
But it doesn't say that they do anything. They said to remove the old floor. So you're telling me you jackhammered the whole concrete out?
No, sir.
You're talking about removing the wood floor that was there, correct?
Yes, there was a tile.
Okay,
And there was holes, there was some holes in there.
you mean holes in the tile and holes in the wood?
Well, you can see that.
All the way through, you can see dirt?
Well, it's not, I'm not talking about feet, full feet. You know, they have holes in them, you can triple hole.
Oh, but if you didn't live there, that wouldn't matter, right?
You be the judge, right?
Okay. Plumbing repair in the laundry. Okay, so you said there were leaks,
So you turn on the water.
but all you gotta do is secure the property. You're not trying to live in it. Why do you need water on?
I don't know what you want to do about. Or we want to come to Texas and probably.
I think you're missing the point because all you were supposed to do was, like the statute said, maintaining, preserving, and safekeeping of the property. That's not maintaining, preserving safety. Because nobody's supposed to be living in there. Why do you need water? Why do you need facilities if you don't need water?
I'm gonna object to the form. That's not the law. Because there's a specific, you can have people live in a house that's redeemed. Because the code talks about, they're not entitled, one of the things they're not entitled to is rents. So this statute contemplates
Anticipates.
a rent. Yeah.
Sustained.
Anticipates.
Move on from this issue. I think you made your point on the concern you have about this.
Okay, so, you said that, by the way, was that former license? Did Mr. Ruffo? And so we got remove appliances. Is that necessary to secure, to maintain, preserve, and safety?
There was a lot of junk in the house. But you didn't do that.
Okay, so and you also said remove cabinets full that are in the house. Was that in order to maintain, preserve, and safety of the property?
You didn't do that.
Okay. And then you cleaned up the yard, remove trash and debris. Does that maintain, preserve, and safety of the property?
Then again, when you have to be there and to do that, that's the city furniture.
Okay.
If you do that, you need trouble. And you, that's part of.
Oh, non-responsive. Okay, so you also said you replaced the window.
Overruled. I think it was responsive. Overruled.
Would you, you said you replaced windows? I don't see a expense for windows. Either labor or a window expense. Okay, you also said you replaced the door, but I don't see any replacing the door.
We just try to, when my dad passed away, try to get on the field. We try to find out. And so I don't know, it might not be in there, we made, maybe not even this, so we did replace the windows, we did replace the door.
Okay. So, let's move on to the, you'd already told me earlier, you never got on the roof. Is that correct?
That's right.
So you don't have personal knowledge as to the disrepair of the roof.
It was leaking inside the house. You don't have to be on top, you can see the leaks. The drywall coming down there.
Okay.
Collapsing from the beginning.
At that point,
I'm not a roof.
so, could have not just done a spot fix.
We tried.
You tried to do a spot fix.
Yes, we looked at our options. We didn't have to do that.
So you had to replace the whole roof. But even your own attorney thinks that's over the top.
No, I object to that. He doesn't know what I think. He knows what we did, and we cut it in half, because we thought that would be proper. But, if he wants me to ask for the 10-2, we can do an amended exhibit, and I'll add the other 5,100 on there. So, what we presented to each other, but to suppose what I think about it, I think we're moving on.
And what before the court is just the evidence and the attorney statements and questions about evidence. So.
All right, so, going to painting, how is the painting part of maintaining, preserving, and safety of the property?
If you don't paint the house for 30 years, the wood, everything, you'll have termite and everything, and you have to do something to a property, obviously. But I don't know, it's like, you be the judge.
But like, the
No,
painting came out of the
we didn't go over there try to make it real hard, we just put paint on it. We don't put paint on your wood, what happens, so it'll get eaten up. We wouldn't want our property to fall down to the ground. And just die. I mean, we bought the property because we wanted the property. We try to keep it safe, we try to keep it in good standing,
So,
it is in the city limits. And just leave it
objection, I know.
Overruled. It's responsible. Overruled.
All right, so we have receipts to MGPC. That's the guy that moved into the house, right?
That's correct.
And so the money, was paid by MGPC.
Those are receipts that the guy, we had to reimburse for because we couldn't sell the property. When we found out we couldn't sell the property, we were gonna, fighting us for the property. And my dad told the guy, you know what, I'm having issues. Can I sell you the property no longer? If we have issues, and here we are stipulating the issues of the house.
So, okay, so the dates of these receipts are 7/5/18, 7/10/18, and 7/24. Then this is part of your exhibit number 4. You remember that? Okay. And so at that point, Mr. Vega had already moved into the house and started to do work.
I couldn't tell you exactly the dates now, but I suppose it was.
Okay, and then, and on July 31st, it was redeemed after we moved in.
I don't think I said again, I don't know the dates, but that's the dates, that's right.
Okay, do you have, obviously you got receipts from Mr. Vega when he paid for the paint. Do you have a receipt where your dad paid back Mr. Vega?
I don't know,
Does one exist?
I don't know, I have to go look.
So we don't really know if he paid it back or not.
Oh, yes, you can put that, or else the guy will not do it. He won't do it.
The under the statute, and this may or may not be, this may be an argument to the judge. But according to the statute, after redemption, there's a portion where we're supposed to ask for the expenses that were incurred in this thing. And you, as the property owner at the moment, have 10 days to give us a breakdown of the expenses in this matter. Is that correct? Like before you give us a roll-on sheet with all those expenses?
Am I supposed to give you a sheet? What do you ask?
Mr. Cunningham provided us with your information detailing all the expenses that you wanted reimbursement.
So what is the question? Did he give it to me? Or
Did you provide him with the expenses that you wanted reimbursement for?
yes,
And then he put it in writing.
is that correct, Mr. Fernandez?
I don't know the question. I don't understand. I'm not following.
Yeah,
Are you asking what he gave his attorney? As far as information?
well, I just wanted to know that if you remember giving information about the expenses you wanted reimbursement.
How would the attorney otherwise know if he didn't give it?
He gave that information to Mr. Cunningham.
I don't have a receipt. We're not hiding anything from the court. If I had a receipt, I'd have it marked.
No, that's not my question.
What's your question? What's your question?
What are we asking for?
Uh, what I'm trying to get at, as a way of explanation, is that by statute, you have to provide within 10 days, they have to provide to us within 10 days the expenses that they want reimbursed, or it doesn't count.
So, okay,
All right.
so how about, did you provide within 10 days?
We didn't know we were put to this point. We didn't know we were gonna lose the property. in the first place.
That's taken way out of context. That doesn't have anything to do with this lawsuit. There is a provision in there that if they offer us costs and expenses, then we're supposed to do. There's a whole triggering mechanism to where if we send them a cost and expense list, if they ask for it, which they didn't ask for it, and we went through this in a whole deposition, they never asked us for an expense list. So they can't insist on the 10-day trigger if they don't ask us. They never asked us. They wrote a letter. It's in the deposition transcript.
I'll review the statute.
It's just-
That's never been before the court before, but I'll review the statute and
Well, and it's probably in the court's record, because it was not offered as an exhibit in the case. The reimbursement that they were looking for. That is an exhibit.
you're talking about today.
No, well, our case, well, not here, there's an exhibit in there. And part of the problem is this $10,000, $200, $10,200 roofing bill isn't part of that exhibit. Okay, that's just, I want to bring that up.
Okay. And I may well ask for some, what I call letter briefs on those kind of loose issues.
Okay.
Because we haven't really talked about that. I don't remember that being the report before. That means nothing because it's been so long, but, make a note to remind me at the end of this case about that issue. So we can, I need some more information on it.
All right. Earlier, we spoke about mail approach.
Yes, most sides may freely approach.
This is a warranty deed. Okay. Do you remember, you recognize that signature? No. Okay. So, this is a document in which, your dad sold his property to Mr. Guadalupe and Oliver. I think it was that. Anyway, for $110,000 according to the document. And with a vendor's lien, which means that it was sold on a note, like he financed it, okay? So he was raising the payment. And what's that date on there? Okay. So, and then let me just make sure you recognize your mom's signature. Okay. So they were receiving payments on this since 2018. St. Andrews Investments, John, if you'd like to do this, I'd like to.
Exhibit one. Respondents exhibit one, response.
No objection.
The respondents exhibit one is. No. And I'm assuming while y'all look, I'm assuming this is probably the only witness.
I have mine fine.
Okay, but that's about all we'll have.
Right.
There's no, anybody else.
Well, and attorney fees, I think.
Okay.
Yes.
Okay. And so this is the original exhibit?
That is, yes.
Remind me. You have the others?
Um, St. Andrews Investments, redeemed that property on July 31st, 2018. So your dad has been receiving payments on that property from that date till, we don't know, right? It's still in the same, in that name.
Like I said before, my dad slowly, to the guy. When he found out that he couldn't sell the property, he had to reimburse him everything back.
Your dad was a really, good businessman. He was kind of like an impresario, yeah, he was very good with real estate, right?
So,
Well, he had 100 properties, so that's pretty good.
you do something right.
Yeah. So, well, if he was going to take a property back from someone, because he's already done 100 deals, why wouldn't he have that guy also sign a deed back from someone?
You know, I'm pretty sure he did.
Well, there's nothing else after that high that document we just did. There's nothing else to say about it.
And I can assure you that there's a very high possibility that he's going back. I will probably have to go back to Gold or Asher and ask him. And see that he has to send it back. He needs to give it back, you know.
Yeah, no, I don't think so.
Well, and now, if I can prove to you, I don't know what you're trying to get out of it, but I'm telling you, my dad did sell the property to the guy. When he sold it to him, he found out, when we bought the property right at the auction, it was us that really bought the property. We bought the property at tax sale. We did, not her. We did. She tried to get it back.
Your Honor, I'm not even sure what he meant to me.
Essentially the question. Well, you'll have an opportunity. But
What I'm trying to
hang
tell
on, hang
you,
on, hang on. I heard that the public records don't have it that other deed.
That's correct. All right, that is not. All right, so the next thing is, when this, or when St. Andrews Investments redeemed in 2018, y'all continue to receive payment on that property after that date. You don't know? You don't know?
do you have records of it?
No, just answer the question. Did you continue to
I
receive?
don't remember. Then, when we found out the property, they were finding us for the property.
That's okay. No, you don't remember, right? You don't remember.
I don't know.
It's all, just answer the question. Well,
You have a. In the, exhibit 5.
Yeah.
Did you help prepare this?
That's what we're gonna do.
Okay. So you don't really know whether all these numbers are right?
You gotta know. That's good.
Just it's a summary of the evidence, that's all.
it's a stag. It's,
I would just say it's more than a summary of the evidence, that I can actually say things that aren't necessarily on record.
that's for cross-examination. So as the document, it's admitted as a summary. You may think it's an accurate summary, which is why we cross it.
All right, so at this point, we've got on here all the different, we've already gone through that. We've got ad valorem taxes of 2016 to 2020, which, you know, the property, which if you think that the property was taken over in 2017, and 2016, 2017 wouldn't count because that was part of the, you know, tax code, correct?
That's not a question, it's a legal argument. The document itself tells us, this argument about this title is irrelevant to this case. Because the evidence shows, the tax district's evidence shows who paid the taxes. And it wasn't Mr.
I
Baker.
understand.
It's
So-
Mr.
What's your question again?
Valdez paid the taxes.
What's your question?
My question is states that 2016 and 2017 are part of this ad valorem thousand, 8,152. But the sheriff's sale was in 2017, which encompasses those years. So it's kind of like, it's a double dip. Okay, we can't do both.
Hang on, hang on. Ask him a question. If he knows the answer, he can answer it. If not,
That's the question.
When you buy a property at a tax sale, sometimes they can go back 2 years. They've been changing it every year. They change it all. I've been buying properties at the tax sale. Sometimes they charge you 2 years back or 3 years back. They can go back. I don't know if they can go back just 2 years or 1 year, but it's been changing. The law changes every day. But normally when you buy a property at a tax sale, they can charge you. You might be responsible for 2 years back when you buy it.
But what you will agree with this, that when you buy it at the tax sale, you don't owe any more taxes, right?
No, I don't agree with that. When you purchase at the tax sale, I've probably done more tax sales than you have. When you buy it at your purchase price, and then you wait a little bit till they clear up everything, and then they sometimes charge you 1 year or 2 years. It all depends on the county, but the receipts do not lie. I mean, I cannot tell you I paid for 10 years back. I didn't pay it. And the receipt is there. It's okay.
When you pay all the money that you're paying at the sheriff's, right, on September 15th, 2007, taxes prior to September 5th, 2017 do not exist anymore.
Well, it exists. It's not, I'm just trying to be honest with you. You understand me. If it was paid, they wouldn't let me pay 2000. If you're looking at the taxes, they wouldn't. The year that you're talking about, I wouldn't have a receipt for it. You understand what I'm saying?
Judge, somebody had to pay the taxes. It's not a double dip. But there's only one person in this room that paid those taxes when he's not here, unfortunately. But St. Andrews didn't pay the taxes. Valdez paid the taxes. It would be a double dip if St. Andrews paid the taxes and we paid the taxes and we're asking for money back that St. Andrews has already paid. But somebody had to pay for all these years while this place was on the field. So I think that's, maybe I'm not understanding what the argument.
Well, like the argument is that part of the taxes were after redemption that they paid, and part of them were pre-redemption. When she pays for redemption, it pays him the money Mr. Valdez had to pay for the tax, so she's paying him back. So he really didn't actually pay him. She paid.
well,
So now
I think that's semantics. I mean, the point is, they're only paid once. Regardless of reimbursement or whatever, there's not a double tax payment to the county for that.
Well, he can't also get credit for taxes that she didn't.
Is that the point you're trying to make?
Yes,
And that's what you call double dip.
yes.
It's not really a double dip. It's an accounting. It's an accounting issue. It can only be paid once, and if he didn't ultimately end up financially paying it because of reimbursement, then you can't ask for that as damages.
Yes, and maybe I misspoke. That's what I'm saying.
And that's a straightforward argument. And I don't think anybody would disagree with that.
So, do you? I have no questions.
You think
Just a couple.
recross?
If you saw it today, I've asked you 10 times if there was a deed somewhere. You've looked, and this is the first time you've seen it, right?
That's correct. My dad's got, like I said, he's got a lot of properties. It's hard for me to find anything.
It's okay. The answer is that's correct.
The answer is you hadn't seen it. Now, the reason you know your dad paid for that painting bill is because you have those receipts. We do not, I asked you for that too. Find me a receipt, just like Mr. Cordero was asking. Will your dad reimburse Vega for that painting expense? And we don't have a receipt, but you have Vega's receipts. In the possession of Valdez, meaning Valdez would, Vega would have given you your dad the receipt so he could reimburse it. And otherwise, you wouldn't have those receipts, would you?
That's correct. And
That's correct. Recross. Well, you each used about the time that I anticipated, so,
Um, um,
anything further on redirect?
We rest.
Okay, you can sit down, you rest your case in chief. No other witnesses?
No other way.
Okay. Case in chief. Oh, well, those are, that'll get you in trouble.
And some of these don't have stickers,
Well, and I've got them all.
so you know what.
Well, it says it's, they'll have something.
The only one I didn't use was 7.
This is, I think, number 5.
What does 5 look like? What's it look like?
Somebody, so we're gonna have to work on
Okay,
that.
we'll do that.
There's no attachment to 5.
Do I have any,
It's making stickers.
do I have any original exhibit for anybody? I don't. And you got the response, number 1. Okay, call your witness.
how many check?
Come on up, ma'am. Before you sit down, can you raise your right hand? You solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, self you got. See? And I want you to pull up close to the microphone, state your name, spell your name for the board, okay? And we're sitting at about 11:25. So we have till 12, that's what we did till 12, so.
You are the member of St. Andrews Investment, a sole member? Okay. And you make all the decisions in your. Okay. And you are, one of the things, many things, you're a real estate investment firm. And so you were fairly well versed in the redemption statute. And you knew that you could redeem this property, is that correct? And so,
If he's gonna qualify her as an expert, I'm not gonna let him leave. I can't let him leave like that. If she's gonna try to testify as an expert, something, property redeemer, then I'm gonna need it in there form.
I'm not, I was just giving a background.
Background's okay,
And I'm okay with that.
but not anything more than that.
No, I'm not gonna have a talk about the law of redemption.
Okay.
On July 31st, 2018, you filed redemption, is that correct? And we all know better now than we did 2 years ago about how it all works, is that correct? All right, so.
I'm not sure about that, so.
Well,
Under circumstances, I'm not sure about that.
still a little cloudy.
Okay.
Well, Your Honor, I actually know a lot more about it than I knew at the beginning, but that was on July 31st, 2018, correct? And then on that same day, you went to Karen Hood as the tax assessor of the for Midland County, correct?
I did.
And you ponied up the money that you're supposed to do, right?
Portion of it, I put a certain amount and then I found out later I was like 1,800 for it.
Okay, so who calculates? You didn't calculate how much money the redemption was, they calculated, right?
Yes.
So whatever number is the 25% plus the money paid and all the expenses and everything, Karen Hood said you paid a figure, right?
That's right.
And then that figure was $35,912.50.
Yes, sir.
And so later she recalculated, correct? And then she made you come up and spend another $1,469.89, right? Because she said you were short a little bit, but that wasn't your fault, right?
It was.
They miscalculated.
They gave me one, and then take the road to the back of the next.
And so you're, I'm gonna assume that they know what they're doing.
I would say,
Judge, I'm not objecting to the form. I don't know who they is, and I don't
Understand.
know.
Karen Hood, the tax assessor of Midland County, would know how to calculate the redemption value of the motion.
And the same objection, that under this statute, they don't know what cost. All they can do is tell you what to do on a redemption, but they don't know what cost. That's why the statute says you owe what the costs are. You owe the redemption amount and the cost. That's why we're arguing about it. The tax office, the tax assessor doesn't know what that is.
Well, he's just saying, are they following the rules?
I didn't say anything about that. That's a whole different ballpark.
So overrule, but
We can stipulate that it was 35,000 from the calculated from the tax assessor, and she paid for whatever that means, and we're not arguing about that.
Okay, great. Because what I don't
that
want,
include the extra 1,400 and,
yeah, plus the extra 1,469.
Okay.
89.
so you have stipulation, that's the amount?
Absolutely.
Great, all right, and that was important take, and the question, I bring that up because in, petitioners exhibit 5, they do their own calculation about how much money should be spent on redemption. Is that correct? Let me walk up and show you that. See the figures there, like the 25% plus what the redemption amount was. Would you agree with that?
I don't agree with it.
You not agree with it?
And you agree with what Karen Hood, and then the county tax assessor,
You don't agree with the petitioner's numbers?
Right.
You, okay, I got you.
the petitioner's exhibit number 5.
Right, okay. I misunderstood.
Their calculation of what was other.
Karen called the authority with tax officer and also she called me.
Harvey Allen?
Harvey Allen, to get the figures. So she didn't know.
I just misunderstood. I thought you said you disagree with Karen Hood.
No,
Who is Harvey Allen?
he's an attorney for the tax office.
Okay,
He used to do all the tax sales, but they would move to check with him as the attorney for the tax office.
so like double your part.
Yeah.
Okay. So you would disagree with exhibit number 5 and would like to say that the letter from Karen Hood is a more reflective amount that you should expect what your redemption amount is. Okay. There are some questions that have been prepared.
Do we have that letter before the court?
I think the exhibit number 3,
Oh,
and then
petitioner's exhibit.
I'm sorry, yeah, the petition is exhibit 3. And then we amended that, we don't have the second one for the extra money which is paid later. But that's where we're at. And that's exhibit 3. So, you knew that this property, the whole time that we were fighting over it was occupied, correct?
Yes.
And people were making improvements to the property while we were fighting over it.
Yes.
And so a little bit of your concern is a lot of the repairs were for habitation, for like somebody to live in, right?
Yes.
Not just to like batten down the hatches and make sure nobody comes in and steals anything, correct?
Yes.
So you take umbrage with the idea that you would need to fix the AC, correct? You would also take umbrage with the idea that you would need to repair the floors to make sure that, you know, if nobody was living in it, why do you need to replace the floors?
I agree with that.
Yeah. You have any questions?
I'm sorry, what is the question?
Does she disagree with your request for reimbursement of the floor work?
Oh, we could, I think we stipulate that she disagrees.
Oh, that's kind of why you're here,
I want to say something else to it.
but that's not a question. There's not a question about what you want to say. You might ask it.
Yeah, well,
Not until you can't answer until it has a,
is there anything else you'd like to add?
there's a question.
My, mother lived 2 doors down from the school. And I was aware of the house, I've been in the house, there were things in the house. And when I was, and, I did go by the house to look at the house and to peek in the house. The house is not best, but, someone had tried to break in the back of the house, fix the back door. There was a bunch of trash out there, if I took a picture of. And the picture that happened to be in June 18, which was 4 months after all of that was supposed to be cleaned up. I was presenting the bill for cleaning all of that up, but it's still there. I have to put it on my phone with the state. The windows and everything was not that. There's something in the tax. So look at the house from the front. You cannot tell anyone what the end is. It's just from the back.
Okay.
The one that goes.
So your contention is that a lot of this stuff is not.
It was.
And the idea that they're charging for cleanup of the yard on February 5th, when you have clearly a photo that you may present to the court that will buy your testimony on the 18th of July,
On the first June.
1st of June, it's still full of trash.
Yes.
Okay, so they got paid, they didn't do a really good job, is that correct?
Right, I'm sorry, we knew that.
June 11th. And recognize there's water bill and that's there, but did you recognize that the roof was in bad shape when you drove by?
You know, that I would see.
When you poked in and looked through the window, did you see any water damage?
I did not.
And did you get a really good look at it?
I went into the house through the rear and.
Oh, okay, so you actually went.
Yes,
What day was that?
it was June 1st.
June 1st, 2018.
June 11th. June 11th.
And then you redeemed it on July 31st.
Yes.
Okay, so on June 1st, you walked in and tell me what you saw.
June 11th. I went into the back, I saw that he was out there, he was going to work on the house. And I walked through the house. And to assess what else I had other house, see about redeeming. And there was not a lot of damage.
Did that walk through the house go into part of the calculation in your mind about whether you wanted to redeem this property or not? Had it been in the terrible shape that they said it was, or you didn't want to redeem it? Okay, so you were just fine. You personally walked through, not taking him knowledge. You walked through and saw all of it. Did the cabinet need to be removed?
If it needs to be removed, although after, if I were able to purchase it and after the extension period, I would remove them to fitness, but that's what I would want to take it me.
Right. And the flooring wouldn't have done anything.
But anything on the floor with the tile, the pattern, the floor, and just warm, but
Did you see any holes in the concrete? How about the paint? How about the paint?
I just felt that would be a portion of it, the other thing's just old, everything, not even peeled, it's just old, it's, I think it's just spreading the bigger.
Okay. But that was on the interior. All right, how about the outside? How much of the outside? But like that needs to be the integrity, you know, according to the statute, quoting back and forth. Do you think it was necessary under the statute?
My understanding is that important, but that's just my personal understanding.
So, was it being eaten up by termites or anything like that?
Not that I,
So the language, of course, is mainly speech preserving and safety. We should do it right now. So. So you don't think that's the should either, if there was not a leaky roof. And
I didn't see any reason to do it. I thought that's where the back door to the house was big, the one for the washroom had to kick in, and there were a couple of rooms in the back. Walls with that.
how much money have you spent fighting this case to get, this, property back? Right, but it's a lot. We'll put evidence on that here in a little while. Just wanted to make sure that we were all on the same page there. Do you have anything else you want to add?
Nothing other than, as I heard, in the decision, I'm willing to pay what I have to pay by statute. To protect the house, maintain, I thought, like, they could have special property that have there. And this tax bill will close not to do any repairs.
I'm not object to your side.
Sustained.
It's your personal law. If there's a right of redemption. How long's that right of redemption for a residential home? And so, if hypothetically, you buy a piece of property, you just hold on to it for 2 years?
I don't just hold on it, I just try to use it.
Because you might, nobody might not pay them. Right, okay. Pass it.
Well, what do you think the, current, just your opinion, current fair market value of this property is? Assuming, and we all know, you're gonna get the title, you're gonna have the ability to either rent it or sell it. Do you have an opinion as to the current market value?
I don't, if you ask that about the 4 months ago, I could come up with something better than what the property going down.
Just give us a ballpark. I understand the fluctuation.
Just, Your Honor, she's not, she said she's not.
Well, she seems to be an expert on everything else.
Overall, she's got enough knowledge to answer that question.
Yeah, I'm the current fair market value.
As you probably 110.
Okay. About 110. And is that about what you thought it was? The potential upside would be if you did your redemption and got title through the redemption process. That's kind of what, from a business standpoint, we were kind of looking at. You could flip it.
Yeah.
So you said the Sturgeons were friends of yours. That's why you were so familiar with the property. How much money did you pay the Sturgeons to get the right of redemption?
I paid his,
You paid them $5,000 for some property they could have redeemed and ended up with, just like you, $100 and something thousand, right?
well, you said they could have been, I don't know, as far as I knew, they were financial and able, and they contacted me to how to do it.
You could have advanced them the redemption costs and partnered with them, or they could have ended up with some of this.
What's your question?
Well,
You could have advanced them.
You could have loaned them some of the redemption money that you paid, and instead of paying them $5,000, they could have been a partner with you in the redemption. It was their right of redemption, wasn't it?
It was their line.
And the objection was,
Mr. Sheringham is trying to argue that she was profit motivated, and that's perfectly okay under the statute. It's not even.
but he can also argue that.
Huh?
He can also argue that.
But it's not the new statute, but this old statute doesn't have.
Well,
The only reason it matters is because she made a big point of saying she was such a friend of the Sturgeons.
Goes to credibility.
She brought that up herself.
To overrule.
But I'll move on to something else. Ms. Jackson, is it your, I'm trying to understand what you're saying for the court. You're saying that on the date you give a redemption, whatever the tax office tells you to pay at that point in time is the be all and end all. That's all you'll ever owe. Is that what you're telling Judge Robnett? All right. So this idea of, well, they calculated 35,000, so that's all I owe is the 35,000. That's not how the statute works.
Objection, Your Honor, I think you mischaracterized.
Fair argument.
Mischaracterized testimony that we had earlier. Obvious that we said
Well, that-
objection and contradiction.
Overrule, that's not, that's argument, not an objection. What's your objection to the question?
My objection to his question.
Yes.
My objection to the question is he's trying to, like, that we never, he's trying to say that we said, mischaracterizing the questions and testimony earlier, which is not what we said.
Because that goes to the weight and to the court's interpretation of the evidence. There's not an objection to the form of the question.
It's not a objection.
What's the objection?
Mischaracterization of the previous testimony.
That's up to the court as it determines what is credible evidence and not. That's not a, so overrule.
You understand when you do one of these redemptions, you understood it in the statute. That when the tax office told you to pay 35,000, that was good enough to get a redemption certificate, but it might not be the final number that you would have to pay the purchaser. You understood that? Okay, all right, okay. See, I don't hear so good enough. I thought you were saying something else. May I approach?
Yes.
Now, I'm going to show you Exhibit 3, which is your affidavit of redemption. And this was attached to your deposition, which we took. Would you look at that real quickly? And see if you can identify that as a document you signed and, of course, filed with the tax office. Now, on the back of it, you calculated this, not us, not the tax office. You calculated this part, didn't you? On your affidavit that you signed for St. Andrews. Says this property was acquired for 28.7. That's what Mr. Valdez paid, right?
Oh, I see what you did, yeah.
Yeah.
I calculated that to see the rate and the station and the farm and see
So you just broke it down, and it was 28.7, $30 for the sheriff's deed, and then you prepared this document, didn't you, ma'am? Who prepared this document that you signed? If you remember.
Your Honor, if I may, I'm not even sure what you're talking about. I don't know the eggs.
You can go up there. You can look.
Deposition exhibit number 3, the deposition.
I prefer. I'm sorry.
He said he prepared it.
Well, okay. All I'm saying here is, whoever prepared it, and you signed it, they got pursuant to section 3421, I hereby tender to the tax assessor. We're lawyers, Mr. Cadell, right? So the tax assessor didn't calculate. He said, I thought you testified earlier that whatever they say is law, they calculated the 35,000. But In reality, you and your lawyer calculated it. You state right here, pursuant to section 3421, I hereby tender the sum of 35,912, and then you tell us why. Being 125% of the aggregate total, says 125% of the aggregate total of sums paid by Manuel in regards to his purchase of the property. Isn't that what that says?
The reason the parent, I looked at, I figured it out, I checked with her, and she double checked the rest of the is correct, and then I gave her.
The lawyer prepared this and you signed it. And that's not what the statute says. My point isn't to criticize you, but the number you come up here isn't the same.
Yes, you can. Ms.
Can you
Kennedy,
read it again?
wait, Ms. Kennedy, you don't mind if he looks over your shoulder?
Yeah, I don't have a problem. This is what you filed with the tax office, right? I don't really know what the dispute here is, but this is a document your lawyer prepared, you signed, you filed it with Ms. Hood, right? Okay, all right. So where it says, I hereby tender the sum of 35,000, being 125% of the aggregate total of sums paid by Manuel in regards to his purchase of the above described property. That's what he says, right? Right. But that's not really how the statute works, is it?
Objection, Your Honor, I thought we should look at an expert.
I thought she was an expert.
Well, no.
Hang on, stop. You can answer if you know, you're not a lawyer, but you can answer if you know.
No, okay.
We clarified she was not a redemption expert.
No, that's not an objection. Don't talk over each other.
Take a look at this. This is a exhibit on number, I'm sorry, number 2. This is your-
Are these before the court,
I'm not gonna.
or you're just crossing? You're just crossing.
So I'm going to show you exhibit 2 to the deposition control. This is appear to be the letter, but again, your lawyer sent to at or about the time you redeemed the certificate. Can you identify that as the letter sent to Mr. Valdez?
I didn't think that, so.
I don't know what you've been over that with the position. It's not a trick. We talked about it, but
And I said, if I would assume that it is.
did you authorize your lawyer to send a letter to Mr. Valdez? Does this appear to be that letter? If you look at this letter, there's nothing in there where you're telling Mr. Valdez that you're willing to pay any of his costs, right? You did it for that, yeah. You didn't put anything in there about the cost that he was to pay. What you wanted him to take was the 35. I mean, that's all you wanted to pay at that time. That's what you were offering.
That's what it is.
Well, it says, I prepared a deed for your execution, and we got a cashier's check here for you for $35,965, and which represents the cost of the recording your purchase price, and it included premium of 25%. Did I read that correctly? That's all right, Jeffy. But my point is, and it's a real simple one, you guys never back in June of 18 even offered to pay any of this cost.
No.
Okay. And one reason is you didn't know what they were. You didn't know what his costs were.
I did, I was trying to get conversation, but it didn't take all of that.
Okay. Couple more things, Judge.
Okay.
Actually, I don't have any. Thank you, I'll pass away.
Redirect?
And Coach,
Yes.
I forget you giving me over the.
Oh, I'm sorry, I need to ask one question.
Okay. Recross.
Ms. Jackson, you didn't pay, you haven't paid ad valorem taxes, have you, for this property for the year 17, 18, 19, or 20? Have you?
I haven't, as far as I know, the check is still at the treasurer's office.
No.
Include that, I personally haven't paid.
Well, ma'am, you wouldn't have paid in 2018. What you were putting in your 35,000 is just for the $3,000 that were on his back taxes at that time, right?
Up to 17,
Yeah, up to 17.
yeah,
All right. But so you would not have paid the following year's taxes.
18, 19, 20.
Yes. Right. Somebody had to pay those, right? Well, there'd be another tax foreclosure soon if Mr. Valdez hadn't paid them. You didn't pay them.
No, I didn't pay them.
All right.
It looks like they didn't pay.
So are you complaining that Mr. Valdez shouldn't get reimbursed for the ad valorem taxes he paid for those years while we were all appealing this case?
I'm complaining that I shouldn't have to pay the taxes while we were appealing the case and he was receiving the money to take care of the tax.
But
They
you know,
had not been decided. My thought is, at the time that.
now, excuse me, my question is simple. You haven't paid, the only person that's paid ad valorem taxes is Mr. Valdez, right?
Before the was after the tax receipt.
That's what the tax office says. It says paid by manual. Okay. So if he had, are you saying that he doesn't get that under the statute? Are you telling Judge Robnett that he paid the ad valorem taxes? If you disagree with paying that?
If I own the property, I would get it. Who owns the property?
Well, you do. You voted
Someone
apparently.
else's name and someone is living there, so I have no access to the property, so I don't see why I should pay the bill to the property.
Ma'am, it doesn't talk about who occupies it, who lives there. You understand the legal effect of our appeals, one by us, one by you. Was that you've owned this property since the redemption affidavit. Apparently, that's what the Supreme Court says.
I'm not title on it.
What?
She says she's not title owner.
Yeah, but
Judge Robinette.
are you claiming you own this property, Ms. Jackson?
I'm not claiming anything.
You're claiming you don't own this property?
That's what we're here to determine. Judge Robinette has not ruled.
Okay, I'll move on, Judge. I'm done. That's enough. Thank you.
Read.
Let's talk about what you thought was fair and not fair. From the time that we had the redemption, and we've been in a lawsuit all this time, you recognize taxes accrued, right? Taxes accrued in somebody else's name that we don't know, not party to the suit. You could have gone there and paid those if you wanted to, because it's somebody else's property at that point.
I could have, because from what it looks like, Mr. Valdez. And he paid it, I would still, because he felt that it was his property.
He probably was rolling the dice thinking that he was the property. Okay. So,
But you'd already asked for, you'd already taken steps to get the property.
I
To assert your
think
ownership.
It was illegal.
But you had taken steps to assert ownership over the property.
Yes,
The ultimate goal of you occurred, which is to have ownership of the property.
and I think, like Robnett mentioned earlier, and I think I spoke at the turn when I said, well, you already own the property, and then the judge said, well, not yet, because I have a rule. If it's remanded back, I still have to do what they tell me to do, right?
Well, I think I said the Court of Appeals has rules on it.
Yeah.
We're not gonna know.
I think they remanded it.
Supreme Court, I think,
Oh, you just had to.
says she does own it.
So,
I
right?
I think the Supreme Court made it clear what the court is going to do.
Right,
And if I don't, it's gonna be not good for the court.
right. Oh, I understand that. But that's what some of your confusion is. Do I own it? Don't I own it? Right?
My conclusion is, do I own it, don't I own it? I understand the taxes, but if I own it, I'm not getting rent for people living there.
That's the crux from it. All right. So,
We're getting late into that,
okay.
or might be late in my day.
Two more
But,
questions.
wait a minute, but is there anything in the statute or any case law that says that the person in Mr. Valdez's position, who is getting rent, whatever, is penalized on the issue of those future ad valorem taxes after the redemption document?
I'm not worried about that. That's not going to be my question.
No, but that's my question.
Oh, okay, sorry.
So is there anything that I need to know about that she's correct, that they forfeit the ability to get reimbursement?
No, I don't believe that.
So she just doesn't like the way it feels.
That's it.
Right.
That's good.
And you recognize that you may be obligated to pay some of the back taxes. Right. But
They're
you're
not back taxes,
well,
taxes that have already been paid.
yeah, reimbursement of pay tax. So, but during this time period where you haven't had it, they sold it, they're receiving payments on it, and they're making a lot of money off of your property. Is that correct? And you take umbrage with the idea that, sure, I'll pay your taxes. Why don't you give me back all that money you made while you were messing with this? Is that correct? Because you could have been running that property.
Okay, we're waiting, we've been asked and answered.
I could
You're all,
I could have say that I'm having a problem with the renting of the property. There's nothing to say about it, but no, I don't have a problem with that. I don't have a problem with paying the council within my property. The problem that I have is paying for all the repairs that has been done that I wasn't able to okay, that did not need to be done to secure and maintain the property up until the time that I filed it. After I put in for the redemption of the property, I'm willing to pay up to that point because that's what I'm supposed to do. But after that point, go in, put trim and put different things, carpet. I take umbrage with having to pay for all of that because that's cosmetic. That doesn't secure or maintain the property. That's cosmetic. That's what I have a problem with. The money that they made off the property, fine. I mean, I don't have a problem with that. They're invested, I'm invested. I understand that.
There was some discussion about the calculation of this document that Karen did, right? You had nothing to do with the calculation of it, correct? She sent it, she confirmed it with Harvey Allen and put it in a letter. Then you took this and brought it to me. And then I prepared this document, the affidavit of redemption. So what was said earlier was not the correct order in which it occurred, correct? We did not prepare this and then take Karen Hood gave this, and then we documented this. It was done on the same day, correct? Right? Because we didn't want to let anything get crash drawn on our feet. We did it like that, correct? Yeah. So when luckily there's no timestamps on these, but this was that was the order. This, you got this from her, you came to me, and you drafted this affidavit of redemption, and that's where we got the number from, right? I didn't calculate it. No. Okay. All right.
Right, I would,
It has number, but we want to calculate. That's too much liability.
Anything further?
So to summarize what your concerns are, okay,
Just don't I have an argument, summary of argument.
It's gonna be a summary of your requested relief. I'm I've got some information for how I want that to be presented to the board. Just ask questions.
Okay.
Her concerns so far are crystal clear.
Okay. Fine.
Her concerns.
Oh, okay.
That's what
So-
matters.
You don't agree with Exhibit 5? Okay. You're okay with paying taxes that you didn't have the property from 2017 forward, right? And you feel like the amount of the redemption that you paid is the appropriate amount according to the law?
Yes.
Okay.
Thanks for it. Sure.
I thought you'd say that. No, I pass it.
Okay. Any more witnesses?
Your Honor, I would like to put,
First,
attorney fee on.
step down. Thank you. And you, any objection to him testifying from where he is, since he's a lawyer? Well, that's argument. He wants to put evidence on. And,
I don't have a problem. If he wants to do that, and you want to listen to it, that's fine.
hey, raise your right hand. Who's gonna do it?
We're gonna do each other.
Okay, we'll then call somebody. We'll do that. Mr. Gordon, come on up. You're an officer of the court. I'll still place you under oath. You solemnly swear to the testimony you're about to give in this matter, will be the truth, the whole truth, nothing but the truth, so help you God.
I do, Your Honor.
Mr. Cordero will question Mr. Gordon.
I'll have to verify Mr. Gordon's expertise with
Is there a stipulation as to Mr. Gordon's expertise and in the area of attorney's fees in this particular area of rules?
So we're asking, either stipulate the $300 an hour.
No, to his qualifications as.
Oh, yes, no, I don't have an objection to that, of course.
So Mr. Gordon is an expert witness in legal issues specifically relating to this type of real estate for purposes of this case.
state name.
My name is Joel Amos Gordon, that's spelled JOELAMOSGORDON.
And how long have you been practicing?
Since 2008.
All right. And we acknowledge that you're an expert in real estate and do that. So we had some dismiss with all that. Do you have specific expertise now in the redemption area, right?
Yes, I do.
It's a very specific area, right?
It is, yes.
And you're not only just a civil trial, but you're an appellate lawyer too.
I am, yes.
And you would probably have a 50-50 practice in civil practice and appellate law.
No, I wouldn't say it's 50-50, probably, more 75-25, with 75 being, trial work.
Okay. And do you charge more for your appellate work?
I do not.
Did you say, does he charge for his appellate work?
Is I charge more?
Oh, I thought you said he doesn't charge for his appellate work. Okay. You charge more for your appellate.
Okay, you're thinking, what was he gonna do? So, okay, and so we've got a breakdown of all the things that you did here, the drafting motions for hearing registration. You actually got involved in the, after the summary judgment hearing, right?
Yes, that is correct. I was retained by St. Andrews after the summer judgment was out.
And so you got involved to do the appellate work from that point forward.
That's correct, yes.
And so in that time from we show that you did like 55 hours of work, drafting motions, correspondence. I'm gonna go real quick if I can borrow here, so.
It's fine.
Just for your, we'll like add in your exhibit after I go through all that,
Okay.
so you can follow along with me. We've got drafting a motion for reconsideration for 6 hours, preparation for hearing and hearing. We got correspondence, cell phone, 1.5 hours, meeting with clients, 0.5, drafting, filing notice of appeal, an hour, preparation for final hearing, 2 hours, final hearing, 1 hour. And that was a trial.
That was, yes, basically from, the point of everything to file a motion for the hearing up for, file.
Your Honor, we have another hour and a half. Look, I don't want, I'm not gonna argue about that. If he says that the use of the time and it's at 300 an hour, you know, we're not agreeing to pay it, but I'm not gonna sit here and go, we don't need to go through an hour detailing each item. I don't have any reason to believe that, you know, it would be some falsified, you know, document. So I'm okay with it. You know, and I do have two questions, but other than agreeing to 300 an hour for all these hours, I have no doubt for all the work that we put in, that they probably incurred attorney's fees as we do.
So there's stipulation as to that document. That document is not before the court yet.
I'm gonna submit it to the chair.
I will say, just to clarify, the last part of that, where it says trial work, preparation for this hearing, I believe it was 2 hours and then 1 hour for the hearing itself. That is included in 55 up through, I guess, the end of July. There is, I believe, 53 hours. I can't remember.
Additional.
Yeah, it was billed and paid was, I believe, 3 hours. And then I have 2 hours of prep work yesterday preparing for the hearing. And then I think I billed for an hour, just an hour for the hearing today. That's included.
Still stipulate knowing that.
Whatever time he says he put into it, I'm okay with it.
Including what he just testified.
A couple hours for this hearing, yeah.
The 53 extra.
Okay.
Okay. So, is it offered? Mr. Kadir, is it offered?
Yes, it is.
So respondents exhibit 2 is admitted based on stipulation. Paul?
Pass it.
I have 3 questions. Have you been paid the fees that you are requesting?
Yes, like I said, except for the hours that I billed for today, I haven't paid full. I know that the amount that I've been paid total up through yesterday, I guess, was 15,600, and then an additional 900 for preparation and the hearing today. That amount.
Have you reviewed the file prior today and the request to be awarded attorneys and see whether you have St. Andrews has actually pled for attorney's fees in your pleadings?
I did not prepare the case.
Yeah, so, and you haven't reviewed them to know if you've even asked for attorney's fees.
I know that there was a declaratory judgment action that was planned.
Well, that's going to be my third question. Is the statutory is the statutory authority to get awarded attorney's fees? What is that in this case?
Under the Declaratory Judgment Act, it does allow for fees.
And that would be that. And would you agree with me that the work that we put in was primarily involved in these appeals, some of which you filed, one of which we filed, correct?
Yes.
And you never got a declaratory judgment from this court, did St. Andrews?
I think that's why we're here.
I'm sorry?
I think that's why we're here today. That's the final hearing.
Okay.
And the declaratory judgment would be that she's the legal owner of the property?
Yes, Your Honor. I think that's what the declaratory judgment that was asked for originally.
How does
Was
that,
that she was not the legal owner.
how does that mesh with the statute?
Yeah, the actual statute, redemption statute, doesn't allow for recovery of attorney's fees by any of it, does it? Specific.
The redemption statute itself is not.
But were we here challenging one way or another the redemption by parties that agreed and disagreed with what happened?
My understanding is the original summary judgment was for the declaratory judgment, under the Declaratory Judgment Act. That summary judgment was overturned, so we're here kind of on the flip side of that summary, that declaration.
I'm actually here for a trial on the issue of the statute.
Court says
So,
so.
I mean,
I don't think,
Are we? Are we?
I don't think we're here on a declaratory judgment action of the plaintiffs.
Yeah.
I think we're here on just simply under the redemption statute. I don't think there's any question that they own the property. I don't think we have. I don't think I'm in a position to agree that we're doing a declaratory judgment suit here as a part of any pleadings they previously filed.
I'm going to review it all, but
The declaratory judgment was filed and the summary judgment was motion was filed. That was denied. Now we're back to another ruling under the declaratory judgment action. In the original action, if you remember, Mr. Cunningham was granting attorney's fees under the declaratory judgment. Okay, it was.
But that was a declaratory judgment for us, and we did plead it, and we did.
did you plead the declaratory?
And
I don't know, that's the point. I don't know.
Did you, we'll find it if it's pled.
attorney.
Well, did you have a notice pleading? Did you have a paragraph to put them on notice that you're asking for a declaratory judgment, or did you rely upon the statute at hand? Isn't the natural result of the statute at hand that somebody is the owner of the property? Isn't that what the court ultimately declares under that statute?
That's what the appellate court emphasized, yes, but I don't know what we pled. We never, I guess today is the trial on whatever they pled, but I don't know what they pled. Because we spent our time today talking about Mr. Valdez's, I don't think there was an issue today about who owns the property. The Court of Appeals decided that.
We'll go back to the pleadings and consider pleadings that will be considered. And if attorney fees are allowed under the statute, obviously it will be considered, but I'll have to look. I don't remember if it was pled or not.
Well, Your Honor, just that's the issue for you. I'd like to put on my attorney fees.
I'm going to accept the testimony.
Okay.
I'm going to accept the testimony. The issue is it pled? And the testimony will be either ignored or considered based upon what was pled.
The judge, I believe you can consider our attorney's fees, even though we lost on appeal. It wasn't, you awarded, you found, whatever that amount was reasonably earned as a part of our summary judgment. And so I guess I can testify about what I was paid to do an appeal, and you can see where we stand and award as you deem appropriate.
Usually,
I mean, we can do that.
but it's kind of my.
I'll look at it all.
And I think that we fall under the declaratory path. Well, I think we can find some case on for argument.
We're going to have letter briefs coming to. I call them letter briefs, 1-page letter briefs on issues as opposed to, but it has to be pled. It's not pled. You haven't asked for a Rule 66 trial amendment. So I think it's Rule 66, forgive me if I'm wrong, but there's a mechanism for a trial amendment that hadn't been requested. But anyway, Mr. Gordon, I'm going to vote. So Mr. Gordon has testified. Anything further? And that figure is, the total figure is in this exhibit.
Yes.
What's the 53 hours?
Yes, the total attorney's fees, and then the second page has the total costs of the notice of deal.
Nothing's added up. So that is there another document that's going to be added up?
So 16,500, and then he testified a couple more hours.
Oh, 16.5 is in the title. Okay, I didn't.
For the attorney's work, and then at the bottom is on the second page is the total court cost, which is
Second.
$400.
approximately $72.
And does the 65 include the 53 hours?
The 65 does include the 53 hours, it does not include the costs.
You understand that? 65 is everything and except costs.
Yes. We're not agreeing to it, but we understand it.
And I understand you're not agreeing to it. So anything further and any cross? Well, you want to cross?
No.
Where were we?
I'll do it.
Okay.
I'll tell you.
Redirect? Someone's going to call Mr. Cordero. Okay. Raise your right hand. You solemnly swear affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God.
Well, that's not worried about, I'll get the board.
We can do that too.
That's a problem.
We can share that. So I didn't ask them to extend to names, just go to names. Because they,
Patrick.
no, you don't have to. I was just apologizing to her.
This work,
Yes, I'm sorry.
and we have the same stipulations that these network.
I don't have any problems with the qualification.
So that's stipulation as an expert in as a lawyer in this particular area of real estate, which this case relates to.
I think, Mr. Thomas might be covering for the issue with how much I'm charged them. In this particular case, you know, we had gone on 2 years now, and trying to back into all of it. I've got 36 hours of work into it, and that's from the moment that the judgment was filed to fighting the declaratory judgment, the summary judgment. And then I was working with Joel on the appeals, the research, because the great deal of research going through this whole process. We find cases and more cases, and then we had several hearings on this. And through that, I think that's whittled down to what I would have been more, but I think 36 is fair. My treasurer fee for real estate work is $400 an hour. So that number comes out to $14,400. I recognize my time is less than Joel's, but a lot of times my time is conferring with him and doing other things. Once the appeal started going forward, I took more of a back seat, but most of mine came up to the appellate. So I didn't have as many hours at that point. Some research and spitballing about things, but most of my time was prior to. So that's what I'm like.
Any question? I mean, he's testified. Any questions?
No, you're not.
Cross?
Okay, so, Patrick, you submit a bill, a separate bill than Mr. Amos.
That's great.
And so, has St. Patrick paid all of your bills?
No.
Okay. And has St. Patrick paid all of Mr. Amos's bills?
I believe so. If I could explain our arrangement, I've been St. Andrew's lawyer for a while on different matters. So we kind of have a retainer that she keeps with me, and that I just kind of dig into as we go. When obviously we went into the deep water on the appeal, and I'm not an appellate attorney, we engaged Joel to help us move forward. And so we kind of work together on that going forward.
Okay, that's all I have. I just want to know if the bills have been paid. Okay, pass the witness.
Anything else?
No.
Anything else you want to add?
No,
Okay. Any more witnesses? Any more?
no, I'm sorry. We changed my hat.
Your Honor, may I make a call amendment to put on some additional attorney's fees?
Yes. Again, y'all are all officers of the court. As long as we're from the testimony you got to give, the truth, the whole truth, nothing but the truth.
I do.
That's it.
Gentleman named Swank came in on a license to practice law. State of Texas, I've practiced in Lincoln County 47 years. Licensed by the Supreme Court, by the United States Supreme Court, I'm a member of the Bar Foundation. I'm got other things that really are relevant. I charge $300 an hour, and you've heard my prior testimony, that's support to take judicial notice of my qualifications as per that prior testimony.
And there's a stipulation as
There's
to,
no, like, we could play.
In addition to that prior testimony, I was paid $10,000 to do the two appeals. Response to one, and then the actual petition for review with the Supreme Court. And I will just say this, I hope somebody reads it someday. Not one of those courts had the courage to answer the one question that was in this case. And that is, what on earth does section 3422 mean, or 24, whatever it is? The section that we all appealed and we spent so many hours trying to figure out, neither court wrote one word about that. Never told us what it meant. It's just a horrible thing. It's just a horrible, no matter who won or who lost, the process just was flawed. The Court of Appeals didn't do what these people needed them to do. Of course, Ms. Jackson's happy about it. We're not so happy about it, but the process was flawed. Anyway, in addition to my prior fees that you awarded, I would ask for an additional $10,000.
question? Questions?
I have no training. So, I've never seen where the review party gets attorney fees. Have you seen that before?
Absolutely. Oh, yeah. A lot of it doesn't matter. I mean, I don't think the declaratory judgment, and I could be wrong, I haven't read it today, but I don't think it says, only the winning party loses. I think you put on testimony even if you lose the declaratory judgment. It's a judicial dispute. I think you can ask for a recovery of attorney's fees, either side.
All right.
And I could be proven wrong, but
Anything further?
thank you.
For purposes of closing, I've heard a lot and I've heard enough. Obviously, I'm not going to rule today. I would like, and I could really do need letter briefs. I have paragraph briefs sometimes just to make sure I know what's going on. And so we do need a letter brief on the impact of the Declaratory Judgment Act as it relates to the statute, because my thought process is that the ultimate result of the statute declares someone as the owner, and the Declaratory Judgment Act is like another layer. It was not pled, it's moot. Because no one's asked for a trial amendment or anything else that I know of. Has anybody asked for a trial amendment?
I do know it's discretionary to the court. It's not one of those statutes where you automatically get attorneys.
So if it's pled, I need a letter brief on how those statutes mesh and what the attorney's fees picture is for winning and losing parties, because I like those terms because of the nature of the case. And I said something else to you right down that I wanted a letter brief on. Oh, the issue of taxes. I believe that she has now said that she doesn't like the fact that she might have to pay the post 2017 taxes, but that she understands. So that's not an issue anymore, is it?
No, it's not an issue. I think it's not an issue for her. Maybe it's a question of law. There's a loophole on it a little bit, but I think
If you look at it, and you look at it from the other side, and then put that in the part of the letter brief as far as can a person avoid that financial burden under those circumstances. Now, where someone else has been in it because they acted what they thought was lawfully and looked at the statute, used the timing. And we have someone who disagreed with that, challenged, and the ultimate challenge she won. According to the Court of Appeals, which directed me to do something. But I would like to know if there's a loophole, now that you said you'd like to look at that. Is she absolved of is that, as a person in her position, absolved of responsibility to pay that under circumstances? I doubt that that's the case, but I would, but look into it. And it was because you had the concern, even though, you kind of backtracked on it, let them look at it. Was there anything else I needed information on? I think those were the two issues. And so,
Oh, yeah, as a sidebar, I had a fuel bond still pending, for the bill.
that I don't know.
Well,
Because
I think I've said before, right? Submit an order and I'll sign off on it. They ought to get their 27,000 back.
and now
However much they put
I
up.
don't think it would apply if this is appealed. There'd be a new appeal. So I will sign the order. But I think that I need to talk, we need to talk to the district clerk also.
It's been filed for,
The order has,
yes.
that's because I've been out for COVID since
Well, I'm not
Easter.
blaming you.
No, no.
I'm pretty certain you've never.
No, I wouldn't have seen it because I just got back Monday after 100 days. So, get the order to me and there's no objection, and I'll sign it. Obviously, it's not in the stacks that I signed. If someone was signing those stacks, probably wouldn't have signed it because I was gone, April 24th to Monday. Yeah, just get it to me. We'll sign it. I can tell you that the stacks that I've seen, luckily people sign things for me. I don't have this much. I have only that much. It was on. One thing we don't do is wait to sign things. We don't delay rulings very, very often. Now, as far as these little letter briefs, literally a letter brief, a week,
I'm gonna be at the family law practice all week.
okay, 2 weeks. 2 weeks from today is what? August the 19th. August the 19th at noon. And Mr. Cunningham, you'll be able to respond to him. I don't think I had any topics that Mr. Cunningham needed to write a brief on. You might look at the declaratory judgment.
I'm gonna look at the pleadings and the declaratory judgment thing and see where I think we might.
It just was that, it was just never talked about in those terms. So, okay. Anything else I need to look at, consider? Because I'm not going to rule today. I take it under advisement for obvious reasons. But I think both, even though one side is not happy about this and one side is happy, I do think you were well served by both your attorneys, because this is what would seem to be a boring real estate issue became very interesting. So both attorneys are to be commended for their zealous advocacy on each client's case, and it is an interesting case. Now, the new statute kind of clears things up, but we're not really under that. Anything further? Well, that's true.
Did the new statute address anything about this case? I mean, that would have been relevant.
The only thing it addressed that it just added.
Yeah.
It's literally
Oh, you
one
can't
sentence,
off.
one sentence saying
But then that means this case is not in existence.
Yeah.
The point is, it's
after this.
not
Oh,
in
it's not retroactive, but
No.
It was September 1st.
I think so, but the point is, this case would be moved.
Right.
Yeah.
The fact scenario in this case would not be supported by this new statute.
The question, Your Honor, is the timing on a deed for my client. Can we look at that?
Well, for purposes of that, can I just do an interlocutory order? Because that's going to be the result ultimately when I rule, because that's what the Court of Appeals said, and then the circumstances of the statute, when they read it, I don't think Mr. Cunningham's going to be surprised by that. And he said that he would do it, right? The deed?
Yeah.
Any objection to be signed an interlocutory order, that the deed be prepared and signed, and
oh, no objection, no objection. We
Okay.
need to move on with that. Yeah,
all we're doing is the money part now and the damages and
they need to get their money back on that, and yes, and they need to get
so the court,
title clip And I'm really worried now, that when I know about the vacant deed. I mean, do we know where Mr. Vega is? Do we locate Vega? Maybe, I think as a matter of law, that deed is voidable. It's a encumbrance against her title. Is it?
But it's not a part of the public record. So it's not on file?
Yeah.
That
it shows
deed-
that
that
it
deed
was
is-
actually
Oh, that's
filed.
that deed.
That deed.
Oh, there's something, okay, the other one was that.
So if we have a problem, we need to get that, released or presented or something.
I'm pretty sure, almost 100% sure, when my dad reimbursed that guy back, that guy went, after company and sent it over to him. It might have not been recorded, but he did.
Well, you think he repeated it back to your dad?
Yes, he did. My dad, when he reimbursed him, I'll let you.
Well, that's a problem, that's a problem.
My mom
It
had to
could
pay
be a problem, yeah.
when my dad reimbursed me money back, he signed it over back to my dad.
Well, that's an issue. It doesn't change, it's not gonna change the interlocutory order that that the transfer back take place, but it is an issue. And so that needs to be resolved. So I'll sign an interlocutory order when presented with one, the 19th or whatever, or next week, whatever. And that has to be
You
clear.
know, you could do it, re-judge them themselves, but whether the judge rescinds it or voids it, because we didn't have the authority to.
But as far as the interlocutory judgment,
Yes.
it can be limited, to transfer. And so you'll prepare that,
One other thing,
okay?
there current tenants in there, I don't think it should be our obligation of money to spend.
You're talking about the victim?
Yes, sir, they will.
What is the circumstance with, are they on standby? Are they on standby to leave, and will they leave? Because don't they have the rights under the tenancy to have an eviction?
If they do.
They've been there more than 72 hours?
Well, a month, a month.
Okay.
Overstaying.
It's because they've been there more than visitors for 72 hours. Is that right? Okay. So that's another issue, but that's not before this court. I guess the court,
I think it's our burden to get them out.
if they don't leave, I think the court does have the authority to issue an order on her behalf.
Are we saying she can take possession on the 19th?
Well, I think as soon as I get an interlocutory order, the issue is, can she take possession on the day that I sign it? And I think the answer is yes. And the whole other issue of who,
My concern is if they're on a monthly, I don't know what they are, but if it's a monthly or an oral lease, tenancy. What, you know what I'm trying to say, a monthly tenancy.
month
They're entitled to 30 days notice. for that.
Current, not current.
well, okay, let's assume they're current.
Maybe
How's that?
3 days.
How's that not her responsibility because it's her problem?
Well,
I don't want to solve the issue, but
well.
I think we can get them out.
Okay,
I think we can get them out.
they shouldn't be there.
No, they legally have the right to be there.
Yes, but they put them there. We didn't put them.
Well, but they did their under the statute that they believe they had followed. They
But they were ultimately wrong.
well, but they're legally wrong. They're not squatters.
We're going to give them notice to get out.
They're not squatters.
No.
They had the right to be there because of the claimed ownership that she challenged. She's now successful, but that doesn't change their status to squatter. Those people, the third party.
That's right.
The innocent third party. Have you ever seen this before? I will tell you, in 30 years of practice and 3.5 years as a judge, never saw it. But I know that they don't lose their rights just because
Well, no, they have to be, but whose obligation?
she's the owner. So you have to look at, that's not before the court. How about that? That's I'm gonna punt that to you. comes before the court will rule. Okay. Anything further?
Glad you're feeling better.
Thank you.